Teamwork is essential if the Admissions Review and Dismissal Committee is to work well in developing effective placements for children with disabilities. So too is following legal requirements. If the ARD committee process is flawed, then everyone can suffer. The school district, school personnel, parents, and the children for whom disability law was enacted. This videotape describes 7 steps to maximize the effectiveness of ARD meetings. Featured by special arrangement is ARD Man. Faster than a speeding rocket and more authoritative than the toughest superintendent, ARD Man is dedicated to assisting education personnel everywhere to provide a free, appropriate public education to all children with disabilities. The video is jointly produced by the law firm of Walsh, Anderson, Brown, Schultz, and Aldridge, a professional corporation with offices in Austin, San Antonio, and Dallas-Fort Worth, and by the Texas School Administrators Legal Digest, a monthly legal periodical. Jim Walsh stars as Principal D.W. Do-Right at Blusterville High School. Sharing the spotlight with Jim is attorney Paula Maddox Rawlson from the San Antonio office of the Walsh Anderson Law Firm. Paula plays the role of Debbie the Diagnostician for the Blusterville School District. Other players are identified in the list of credits at the end of the videotape. ARD Man appears as himself. Please note that this videotape is protected by copyright. We remind you that copying in whole or part is not permitted. This video is designed to provide general information on the subject discussed, but is not intended to provide legal advice with regard to a specific situation. It should not be relied upon in dealing with specific cases where legal advice is called for. As the law changes, portions of the videotape that reflect the law as it existed when the video was made may no longer be accurate. Advice from legal counsel should be obtained to guide you through a specific situation. The first of the 7 steps toward effective ARD meetings is to remember that the membership of the ARD committee is important. At Blusterville High School, Principal Do-Right is about to begin an ARD meeting. But Debbie the Diagnostician is mighty nervous. It appears that perhaps not all the required players are present.
Well, we'll get started with our ARD meeting then.
Mr. Do-Right, we can't begin the ARD meeting yet. We don't have a regular ed teacher here.
Well, we don't have all day, and we've got Mr. Goodhart here. We're going to go forward. Now, Mr. Goodhart, I'm glad to see you could take time off to join us today for the ARD meeting. And Laura, I'm particularly glad to see you. We always like it when students take an interest.
Excuse me, Mr. Do-Right, I just wanted to come by and let you know that there's a crisis in my classroom, that I really feel I need to be there, so I just want to let you know I wouldn't be here for the moment.
Okay, that's fine. I know what you're dealing with, so go take care of that and just get back when you can.
Yes, sir.
All right?
Mr. Do-Right.
Debbie, we're going to go forward with our meeting, and I believe you've got some recent testing to tell Mr. Goodhart about.
We had a chance to review my assessment report prior to the meeting. I just want to hit some of the highlights of that report.
Excuse me, pardon me again. Ms. Fuzzball, the problem that I've been dealing with has moved down to your content mastery room, and I think you better get down there and check it out.
Absolutely, yes.
Mr. Do-Right.
No, I need a teacher in that classroom right away. Go on there, Ms. Fuzzball.
But I wanted to ask her a question.
Well, I'm sure you did, Mr. Goodhart, but she has a conference period every day. You can ask her your questions tomorrow during conference period. We're going to go forward with this meeting, Debbie.
Later, we find Debbie relaxing at home.
Oh, I am so tired. These ARD meetings take forever, and they are so complicated. I wish there was somebody I could talk to.
ARD Man!
Who are you?
I am ARD Man. I seek an appropriate IEP for each child, a placement in the least restrictive environment, and a free and appropriate public education for all. Fear not, O lonely Diag. ARD Man is here to help you.
Can you really do that?
Try me.
Oh, ARD Man, you wouldn't believe what happened today. We had an ARD meeting where not all of the required members were present. First, we had one teacher that was absent. When that teacher arrived, another teacher left the meeting. I fear that not all of the required members were present for the entire meeting.
A common problem. ARD Man says you can't play the game without the whole team.
Wow.
The Admission Review and Dismissal Committee is supposed to work as a team. Like any team, the ARD Committee is comprised of several members, each of whom has an important role to play. Let's take a look at the legal requirements for the membership of the committee. Federal law does not use the term ARD. Instead, it refers to the IEP team and sets out 5 required members of the team. First, the parents of the child are members of the team and must be given an opportunity to participate in all ARD meetings. Second, a regular education teacher if the child is or may be participating in the regular education environment. Third, there must be a special education teacher or special education provider for the child. Fourth, there is to be a representative of the local education agency, a position which is often referred to as the administrative representative. Fifth, there must be someone present who can interpret the instructional implications of the evaluation results. Those are the required members for any ARD meeting. However, others may be present and often are. Parents are welcome to invite to the meeting any person who, in the parent's judgment, has special knowledge or expertise regarding their child. This might be an outside expert, an advocate, friend, relative, or lawyer. Likewise, the school district is free to bring others with special knowledge or expertise, provided that the school notifies the parent of its intent to do so. Also, the student can be present at the ARD meeting, if appropriate. And once the student reaches age 14, it's required that the student attend the meeting if the ARD will be discussing the plan for the student's post-high school transition. ARD Man is right. All members should be present. But the law anticipates that there will be times when the school district cannot persuade the parent to attend the ARD meeting. In that event, the school is authorized to conduct the meeting without the parent. Now that we have some information about the composition of the ARD committee, let's see what happens when one of those outside experts shows up.
Step 2 is to make sure that ARD committee decisions are based on assessment data. When the ARD committee next meets, the parent has invited an outside psychologist, the eminent Dr. Hans Bigbrain, to the meeting. But Dr. Bigbrain is a bit frustrated that the school is not following his recommendations.
You know, Doolittle, this happens every time I come over here. You know, this girl, she got a problem. She got an emotional problem, and she needs help. And you know, I'm the only psychologist that's examined this girl. And even your own behavior specialist here, she agrees with me. The girl's got an emotional problem, and she needs help. Have you even read my report?
Dr. Bigbrain, I don't need to read your report. And I don't need the recommendations of a behavior specialist. We've got a perfectly good program here. We've had it for a long time. We've put a lot of kids with emotional problems in this program. All of them have been successful. It's worked for everybody else. It'll work for this girl. So we're going to put Laura Goodhart in this special program we have for kids.
Oh,
Ms. Fussbaum,
brother.
I'd like for you to speak up
Looks
a little
like
bit
I'm
on
going to
this.
need
Haven't
another
you
visit
had
from
other
ARD Man
students with
tonight.
emotional problems who have gone into this program?
ARD Man? ARD Man? ARD Man?
ARD Man!
Oh, ARD Man, you should have been at our meeting today. The principal actually told the parent that we wouldn't look at any assessment data. Instead, we were going to do what the principal wanted.
Ignoring the assessment data? Not good. Big problem. ARD Man says all decisions must be based on assessment data.
The assessment data is to the ARD committee what the evidence is to the jury. Decisions about eligibility, the content of the IEP, the related services to be provided, the placement, all of these must be based on assessment data pertaining to that particular student. If there is one cardinal rule in special education law, it is that decision-making must be individualized. The best way to make sure that that happens is to focus the attention of the ARD committee on the assessment data. Now, assessment data is not just the formalized testing. It also includes information provided by classroom teachers, grades, and informal assessments and recommendations. It also includes information provided by the parents as to the student's life outside of school. Reports from outside experts like Dr. Big Brain are a particularly important form of assessment data and should be carefully considered by the ARD committee. Decisions based on administrative convenience, or the way we've always done things, or what fits into our budget and program, are always vulnerable to legal attack. Decisions based on assessment data of the particular student in question will survive any legal challenge. To illustrate this point, we like to use the ARD pyramid. This shows that serving a special education student is like building a pyramid. It all has to rest on a firm foundation, the assessment data. If the assessment data is ignored, chances are the IEP or the placement will not fit the student. So remember to keep your focus on the ARD pyramid. Debbie, the diagnostician, was so impressed with the concept of the ARD pyramid that she had it drawn on an easel for display at the next meeting. She was hoping that this would help all the members of the committee. But then it seems that Mr. Do-Right is not exactly a quick study.
Step 3. Decisions must be taken up in order. The ARD committee has gathered together and, under Principal Do-Right's leadership, decides placement of the student first, then moves on to develop the IEP. Debbie appears under stress, as Do-Right says,
Okay, well, I think that we've talked all about the testing results and the grades and the recommendations, the reports. We've talked about all of the assessment data, and it's time to move on to the most important part of our ARD meeting, and that's the actual placement decision. So it's time that we talked about where exactly, Laura, the placement. Yes, I said the placement.
The pyramid.
Yeah, the placement
pyramid.
is right there on that, and so we're going to talk
Mr.
about
Do-Right,
where, Debbie, we're going to talk about placement now. So let's talk about exactly where Laura will be served in our high school this year. Now, we've agreed a variety of things, and so I think that concludes our discussion about placement, and it might be a good time to take a short break. Why don't we take a short break, and when we come back, we'll talk about Laura's IEP. All right? Let's take a break.
ARD Man? ARD Man, I need you right now. ARD Man? ARD Man? ARD Man?
ARD Man!
Oh, ARD Man, we just decided this student's placement, and we haven't even begun to talk about the IEP. That's not right, is it?
ARD Man says, you can't build the pyramid from the top down. You build it from the bottom up.
Oh, ARD Man. I need to get something from you after the meeting.
Okay, well, I guess that just about wraps up our break, and we're ready to move on. Are we ready to move on? Yes. So let's move on to the next step in the IEP process, shall we, Debbie?
Right. Well, we've already talked about placement, so let's back up and talk about programming for Laura. Now, the first thing we need to do is establish some goals and objectives for Laura. Building the pyramid from the bottom up is not only good advice for building contractors, it'll also avoid legal problems in the ARD process. One of the most important commitments the law has made to students with disabilities is that they will be served in the least restrictive environment, or LRE. The least restrictive environment is the educational arrangement that provides the student with as much contact with non-disabled peers as is appropriate. Each ARD committee is duty-bound to place each student in the least restrictive environment in which that child's IEP can be appropriately implemented. So you must write the IEP first and then discuss placement. That's why the ARD pyramid moves from assessment data to IEP and then placement. This means that the ARD committee should come to consensus on a number of things before the issue of placement even arises. For example, the committee should discuss and agree upon the following. First, the child's present levels of performance. Second, appropriate and measurable and annual goals. Third, short-term objectives or benchmarks along the way to those goals. Fourth, the extent of special education services to be provided to the child. Fifth, related services to be provided to or on behalf of the child. Sixth, the supplementary aids and services that will be needed. And seventh, any program modifications or supports needed by school personnel to serve the student appropriately. If you decide on these IEP issues before turning your attention to placement, you will be prepared to ask the right question, which is, now that we know what the student is going to need, what is the least restrictive environment in which those services can be provided? If that question comes up after the IEP is written and agreed upon, your placement decision should comply with the LRE requirements.
Step 4. The district should be clear about its commitments. While Mr. Dewright is away at an important meeting, his assistant chairs the ARD meeting. As the meeting comes to a close, the parent is trying to make sure he understands what the district is going to do.
So, you've agreed to a new assessment?
Boy, I'm sure glad these special ed folks are here to take care of all this stuff.
And you're going to look into some new assistive communication equipment?
I'm sure not going to do this stuff.
And someone will let me know who is going to be doing the daily notebook.
I'm glad I've got Debbie here to make sure we follow up on all this.
ARD Man!
ARD Man sees what's happening here. You're making commitments that no one will keep. ARD Man says, don't leave the meeting without a promise list.
A promise list is just a management tool to make sure that we follow up on the commitments we make at the ARD meeting. Oftentimes, parents and school personnel leave an ARD meeting with very different perceptions as to what has been agreed to, who is going to do what, and when it's all going to happen. The promise list is a simple device to try to prevent that from happening. Here's what it looks like. The promise list identifies the specific commitments made by the school district and attaches a name and a date to each one. For example, this one indicates that Ms. Holbrook will complete the evaluation of assistive technology devices by October 23rd. One of the most frequent issues in special education litigation is the promise not kept. The parent alleges that the school made a commitment to do something and then didn't do it. The school argues that the parent was mistaken. No such commitment was ever made. Wouldn't it be nice to avoid conflicts like that and all of the bad will they tend to generate? That's what the promise list is designed to do. And if it accomplishes that, we think it is worth filling out one more piece of paper at the ARD meeting. A promise list works best when the parents and the school are in consensus as to the child's educational program. But sometimes, no matter how hard you work at it, you are not going to reach consensus. Let's move on then to our fifth step toward effective ARD meetings, knowing how to handle the non-consensus ARD. You know, we've been at it, and I know everybody's getting very tired here, but we've got to try to reach consensus at this ARD meeting. I mean, that's our task, so we need to do that. Mr. Goodhart, we've been at it for a long time now, and we don't seem to be reaching consensus. It seems like everything we propose you disagree with this time.
Well, what's wrong with that?
Well, there's nothing wrong with it, sir. I mean, you have the right to do that, but sooner or later we've got to find a way to resolve this. We've got to come up with a plan for the girl. So what I'd like to suggest is it's an old way to resolve disputes, and it's very fair.
Well, how are you going to, what is the old
Well,
way?
I'll tell you. If you just listen, if you make a fist with your hand, and we're going to count to 3, you and I, and it's 1, 2, and on 3, you go rock, paper, or scissors.
That's ridiculous.
Well, no,
what is this?
Oh, there
It's
has
fair.
got to be a better way. ARD Man!
Well, Debbie, I heard about this figment of your imagination, this ARD Man, and obviously he's not coming, so I'll tell you what. I need to take a little break here. I need to make a phone call. Y'all see if you can figure something out. I'll be back in about 5 minutes.
This is really great. Wow. And these people teach you.
Rock, paper, scissors. This is no way to settle disputes. ARD Man says you must be prepared for the non-consensus ARD.
State law tells us that the committee shall develop the IEP by agreement of the committee members, or, if those persons cannot agree, by an alternate method provided by the agency. Majority vote may not be used to determine the IEP. And indeed, the Texas Education Agency has come up with an alternate method. That alternate method requires, as a first step, that the parent be given an opportunity to have the committee recess and then reconvene. Texas rules tell us that when mutual agreement about all required elements of the IEP are not achieved, the party, parents or adult student, who disagrees shall be offered a single opportunity to have the committee recess for a period of time not to exceed 10 school days. The committee should agree to the date and time for reconvening, which must be within 10 school days. During the recess, the members can consider alternatives, gather additional data, prepare further documentation, or obtain the assistance of additional resource persons. Keep in mind that the recess is not required. It's a parent's option. However, in some cases, the recess need not be offered. Texas rules say that this recess is not required when the student's presence on campus presents a danger of physical harm to the student or others, or when the student has committed an expellable offense, an offense that might lead to an AEP placement. Once the committee reconvenes, the hope is that it will now be able to reach consensus. Keep in mind that one way to do that is to agree to an IEP of shorter than normal duration. If the parties cannot agree on the plan for the year, perhaps they can agree on the plan for the next semester. Be that as it may, there will still be times when consensus cannot be achieved. What then? Our state rule in Texas says if a 10-day recess is implemented and the ARD still cannot reach mutual agreement, the district shall implement the IEP which it has determined to be appropriate for this student. So the general rule is that the school district will proceed with its plan if the conflict cannot be resolved. Keep in mind that this does not apply when the student is up for consideration for special education for the first time. Students cannot be placed in special education without parental consent, but in other disputes, the school's plan is to go into effect. If that happens, the administrative representative should be absolutely certain that the parent understands how to challenge the school's decision by requesting a due process hearing or mediation. Moreover, the district should be sure that the parent has received written notice of the district's proposed plan and of its refusal to provide any services the district has refused to provide. A copy of the procedural safeguards should be provided to the parent. We hope you can see that the ARD committee is dealing with some serious issues, and what the ARD puts into the IEP is what is going to happen. This is a lesson well understood by Assistant Principal Jenkins as he chairs an ARD meeting just a few months prior to his retirement. It seems that Mr. Jenkins has had a long and bitter career in education, overworked, underpaid, over-criticized, and underappreciated. Mr. Jenkins has figured out a way to stick it to the school district.
Okay, let's wrap this up.
So, we were thinking that Laura would need a laptop computer to be successful in school, right, Laura?
Right, yeah.
Certainly.
I don't think you understand. I'm saying that she would need this to receive an appropriate education.
Absolutely. Let's get it.
I was going to ask the school district to buy Laura a laptop to take to school and to bring home.
Absolutely, the school will buy it. As a matter of fact, I think what we ought to do is not only buy the laptop computer, we ought to have some training that goes along with it and software, you know, so it's user-friendly to begin with. Write that down in the IEP, Debbie.
Wow.
Wow.
And how about some games? You know?
Yeah, that'd be cool.
Great. And you
Okay.
know, those laptops sometimes, you know, they don't work right and you lose them or whatever. Let's get a second one as a backup. What do you say? Could you use that?
Yeah. Oh, yeah.
As a matter of fact, so it doesn't get scratched, let's get a leather case. In fact, two, because we want one for the back. Put that down in the IEP. I mean, whatever it takes to make Laura happy and successful, that's our goal here at the school district.
That's wonderful.
That'll fix them. I'm going to be the most agreeable ARD member you ever found for my last 2 months around this place.
Debbie the diagnostician and ARD Man are at her place sharing a glass of wine. They've been discussing memorable moments from ARD meetings past, when Debbie brings up the distressing events of the day.
And you know what happened today, ARD Man? Our assistant principal gave away 2, not 1, 2 laptop computers to a student who doesn't even need one. Oh, it was something. You know, Mr. Jenkins is retiring this year, and he has figured out, as of his last year, that whatever we write into the IEP, the district is obligated to give to the student. Well, you know Mr. Jenkins, he is really trying to stick it to the district before he leaves.
That's not right. The ARD meeting is no place to work out your personal angst. ARD Man says, if it's in the IEP, the district pays the fee.
I couldn't have said it better myself, ARD Man. The IEP is not a contract that guarantees results, but it is like a contract in that it guarantees that services will be delivered. In other words, in writing an IEP, the district does not guarantee that the student's goals and objectives will all be met, but it does guarantee that the services set out in the IEP will be provided. Several years ago, someone asked for an opinion from the Office for Special Education Programs about an IEP that called for a laptop computer. It seems the school district refused to appropriate the money for the purchase of the computer. OSEP was asked if the school district could do this when the student's IEP required the student to have the laptop. The answer? OSEP said, the law does not recognize any authority on the part of a local school board to unilaterally change the statement of special education and related services contained in the IEP. After the IEP is developed and the placement decision is made, the public agency must implement the IEP. So the rule here is very simple. The school district must provide the services it commits to in the IEP. This has ramifications for the administrative representative at the meeting. Ultimately, that is the one individual who speaks for the school district. Therefore, that person should have sufficient authority in the district to ensure that the services are actually provided. But this also has implications for teachers and other direct service providers. A teacher must fully and faithfully carry out his or her responsibilities under the IEP. This includes the modifications the ARD committee has prescribed for the student. A teacher who fails to carry out an IEP should be corrected by a supervisor. And a teacher who willfully fails to carry out an IEP creates legal problems both for the school district and the teacher. So let's see how our ARD committee members are doing now. Do you suppose they have learned all these lessons, or have we just confused them? Let's look in.
Step 7. It's more about communication than legalities.
Okay, well, I think we've talked about all the other issues around here, and as far as the discipline, we're going to have a behavior plan that authorizes us to put her in the
But wait a minute, you can't do that. That violates a state law. I went to a seminar and learned all about it.
You can so. The art is above the law.
You can't just go against what TEA says. I mean, you can't just make up your own things.
I'm saying there's laws and there are laws.
Stop. Let's hear what the parent has to say. You shouldn't need ARD Man to tell you that ARD meetings are more about communication than legalities.
Why, Debbie, I believe ARD Man would be proud of you.
And ARD Man will be proud of you if you focus your attention on communication with the parents and progress for the child. There are so many legal technicalities that apply to ARD meetings, so many papers to be filled out, boxes to be checked, assurances to be given. Sometimes we lose sight of what this is all about. The ARD process is simply a goal-setting process. The ARD meeting is simply an advanced form of a parent-teacher meeting. Compliance with the law and TEA's requirements is important. What's more important is that the parent is heard and understood, and that the program provides educational benefit to the student. When those goals are achieved, legal disputes rarely arise.
Mr. Goodhart, you'll have plenty of opportunities to ask questions tomorrow. She has a conference period. Too good. That's too good. I love it. I'm sorry. Now, we have talked about this before, Miss Fuzzwell, or Fairball, or Fuzzball, or whatever your name is. I'm sorry. Fuzzball.
The same old thing with you. You know, I agree. This kid has got a problem. On she needs help, there's no doubt. And even your own behavior specialist person here, she agrees with me, you know? And I just can't understand it, you know? I can't understand it. I'm talking Scottish instead of German.
I don't think we need ARD Man to tell us that we need to listen to what the parent has to say. Sorry.
I know.
Yeah, we need a little work on the dialogue here.
Hey, that sounded pretty good.